In early 2021, a public statement issued on behalf of Meghan, Duchess of Sussex, introduced a detail that has continued to attract discussion years later. According to the spokesperson, the amendment made to Archie's birth certificate in 2019 was directed by Buckingham Palace and supported by documentation from senior palace officials. That statement became an important part of the public record because it referred to specific documentary evidence rather than simply offering an opinion or interpretation. Yet, despite years of public interest, no such documents have been released publicly or independently verified. This discussion is not about internet rumors or speculation surrounding the royal family. Instead, it focuses on an official amendment to a legal document, the public explanations that followed, and the questions created when several different accounts appeared without a single agreed explanation. The issue is less about gossip and more about understanding what the documented record shows and what it does not. To understand why this subject continues to receive attention, it helps to begin with the undisputed timeline. Archie Harrison Mountbatten Windsor was born on May 6, 2019, at the Portland Hospital in Westminster. 11 days later, on May 17, his birth was formally registered at the City of Westminster Register Office, well within the legal time period established under the Births and Deaths Registration Act, 1953. The original birth registration identified his mother using both her personal names and her royal title. His father's entry reflected his details as recorded at the time. At that stage, nothing appeared unusual. The document had been properly filed and became part of the official civil register. Several weeks later, however, the certificate was formally amended. Meghan's personal given names were removed from the entry, leaving only her royal style and title. Harry's entry was also updated to include his princely title. These changes were processed through the normal legal amendment procedure used for civil birth records, meaning the amendment itself became part of the official register rather than replacing the original filing entirely. The existence of the amendment is not disputed. What has remained the subject of debate is why it happened. When the amendment became publicly known in January 2021, several different explanations emerged almost simultaneously. Rather than producing a single consistent account, the public record quickly became more complicated. One report suggested the changes reflected a personal decision connected to royal presentation. Shortly afterward, a spokesperson for Meghan issued a statement rejecting that interpretation. According to the spokesperson, the amendment had not been requested by either the Duke or Duchess of Sussex. Instead, the statement said the change had been directed by Buckingham Palace and confirmed by documents from senior palace officials. That wording immediately became significant, because it referred to documentary evidence rather than speculation. If such documents existed and were made public, they could potentially clarify who initiated the amendment and why it occurred. However, those documents have never been released publicly, and no official record confirming their contents has entered the public domain. At roughly the same time, anonymous sources speaking to different newspapers offered alternative explanations. Some reports suggested the change had been requested to ensure consistency with other official documents. Others described it as an administrative misunderstanding involving communications between different teams. Another explanation referred generally to the possibility of a clerical issue requiring correction. These various accounts have never been reconciled into a single official explanation. Because anonymous briefings cannot be independently verified, they remain reports rather than established facts. As a result, the public record contains multiple descriptions of the same event without one authoritative account explaining precisely what prompted the amendment. That distinction matters. Official records establish what happened. Public statements attempt to explain why. When several explanations appear without supporting documentation, observers naturally compare each version against the available evidence. Another point often discussed involves historical practice. Royal birth certificates for previous generations have followed consistent formatting that included both personal names and official titles. Commentators familiar with royal administrative procedures have noted similarities between earlier certificates and Archie's original registration before it was amended. Whether that pattern should have continued or whether circumstances justified a different format remains open to interpretation, but it explains why the amendment attracted attention among royal observers. Viewed objectively, the amendment itself is not evidence of misconduct. Birth records can be amended for legitimate administrative reasons. What makes this case unusual is the combination of an official amendment, several competing public explanations, and the continued absence of documentation that one public statement specifically referenced as confirmation. Those facts form the starting point of the discussion. They do not establish wrongdoing, nor do they resolve the questions surrounding the amendment. Instead, they define the boundaries of what is currently documented and what remains publicly unexplained. As the discussion continued, attention gradually shifted away from the amendment itself and toward the different explanations that had been offered. Rather than producing clarity, each new statement seemed to introduce another interpretation of the same event. That is why many observers began focusing less on the wording of the birth certificate and more on the documentary trail behind it. From an evidentiary perspective, one statement stood apart from the others. The spokesperson's response did not simply deny responsibility for the amendment. Instead, it stated that the change had been directed by Buckingham Palace and that this was confirmed by documents from senior palace officials. That wording is important because it refers to identifiable documentary evidence rather than personal belief or second-hand information. If such documents were ever released publicly, they could help establish exactly who initiated the amendment, when the decision was made, and the administrative reasoning behind it. To date, however, no such documents have entered the public record through official publication or independent verification. That absence does not prove they do not exist, but it does mean the public cannot evaluate them. By contrast, the alternative explanations reported in newspapers relied largely on unnamed sources. One report suggested the amendment was intended to align the Duchess's name with other official documentation. Another indicated there may have been a misunderstanding involving communications between different offices. A further explanation referred generally to an administrative correction. Because these accounts originated from anonymous briefings, they cannot be independently verified in the same way as signed documents or official statements. This difference is significant. Anonymous sourcing can provide valuable information, but it carries a different evidentiary weight from official records. Responsible analysis requires distinguishing between verified documents, attributed public statements, and unattributed reports. Another aspect that attracted attention involves the individuals responsible for royal administrative procedures during that period. Samantha Cohen, who had served for many years as a senior palace official before assisting the Duke and Duchess of Sussex, was closely involved in supporting the household during its early months. Her extensive experience with royal protocol has led some commentators to suggest that the original certificate reflected established administrative practice. Others argue that later circumstances may have justified revisions. Publicly available records do not provide a definitive answer. The broader legal framework also deserves consideration. Birth certificates in England and Wales are governed by statutory registration procedures. When an amendment is made, it becomes part of the official record rather than erasing the original entry. Consequently, both the original registration and the subsequent amendment remain part of the historical documentation. That process promotes transparency by preserving the administrative history of the record. Questions surrounding this amendment have also been discussed in light of later constitutional developments affecting members of the royal family. In late 2025, legal instruments concerning royal titles demonstrated that styles and titles are matters governed by constitutional authority. Some commentators have therefore argued that using titles as identifying information on official documents raises interesting legal and administrative questions if those titles later change. Others respond that civil records routinely preserve information as it existed at the time they were created, regardless of subsequent events. These are matters of legal interpretation rather than established conclusions. Importantly, there is no public evidence that Archie's birth registration is invalid or that the amendment itself breached registration law. The official record remains in place, and no court or regulatory authority has found otherwise. The continuing discussion instead concerns why the amendment occurred and why different explanations entered the public record without a single authoritative account resolving the issue. Ultimately, the central point is straightforward. The documented facts establish that an original birth certificate was filed, an official amendment was later made, and several different public explanations followed. One explanation referred specifically to documentary confirmation that has not been publicly produced or independently verified. The remaining explanations came through anonymous reporting and likewise have not been conclusively confirmed. That combination explains why the subject continues to attract attention. It is not simply the amendment itself that generates discussion, but the contrast between documented events, differing public statements, and the limited amount of supporting evidence that has been made available. Until additional official information is released, those questions remain matters of public interest rather than settled historical fact.